limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. Mr. Curry, can you first confirm that you're able to hear me so far?
Yes.
Okay, and your video and audio is very clear as well.
Yes.
Okay, we're here on motions that the state filed. A motion, I believe it's a motion to introduce audio visual testimony of a child and motion for a protective order on that audio visual discovery. Is that correct, DA Lezay?
That's correct, Your Honor.
And Attorney Belskis, have you been able to familiarize yourself with the request?
Yes, I have, Your Honor.
And what is the position from the defense?
Well, first of all, there's several issues here. We've also received a notice of intent to introduce medical records. And what I think is important to note first starting off is that this is scheduled for trial February 10th and 11th. Mr. Curry has filed a speedy trial demand. We have asked before that his bond be amended, which has been denied by the court. And so here we are now less than 2 weeks before trial, and we get notice that on the 18th of January, that there's medical records that they intend to introduce, which we have not received any copies of. And it's interesting because in terms of the medical records, we had brought out at the preliminary hearing that she had not gone out to any medical treatment. And that was affirmed by the state's witness. And now all of a sudden there's medical records that they want to introduce. Also, we have not received copies of the audio recording of the 7-year-old. So basically what happens is that, and this is kind of common, is that the DA says, well, we have this discovery. We're not going to give it to you unless you agree to a protective order. Now, the problem is that how can we make any determination if we don't know what the evidence is? We haven't been given copies of it. It's not like they gave us copies and said, okay, we want this protective order, and the court could say, put an order saying that you can't disclose it until this issue is resolved. So our biggest problem is now we're less than 2 weeks from trial. They're introducing supposedly other discovery that we haven't received. So just from in terms of discovery violations and things of that nature, we're just asking that basically the court deny the motion because it hasn't been provided. It doesn't give the defense sufficient time to respond and also to prepare for trial. The other thing is that in its motion to for the protective order, it basically indicates that the audio-visual recording is that of the alleged victim. It's not of the alleged victim, as far as I can tell. And if there is an audio-visual recording of the victim, we deserve to get that. From what I understand is that it's of the 7-year-old who made a statement to the police officers earlier. So what we have is we have a situation where Mr. Curry demanded a speedy trial. It looks like, from what I know, is that this interview occurred in early December and still wasn't given to the state or given to the defense until a notice came out in the middle of January. So I don't think that it's a good faith effort to comply with the discovery statute. I don't think that enough evidence has been presented for the court to act on this. And in terms of the medical records too, I want to point out that we have information that the so-called victim in this case had problems with her ear even before this incident, and there might be medical records to show that, but we haven't been given anything. So I don't know how we can, respond and how, we can be ready for trial if these items are allowed in.
DA Lizette?
First of all, Your Honor, I mean, I would point out this case is actually a relatively recent case. It's not a situation where we've been sitting on this information for months. The preliminary hearing took place in October. The statute with respect to the child video statement requires that we provide this notice to the court within 10 days of the trial. So we're not even to that point. We actually provided it well in advance of 10 days of the trial. We've asked the defense to sign a protective order in order to receive that information, both the audio video recording as well as the medical records. If there was an issue with respect to the protective order, which really just prohibits distribution or sharing of those materials, then the defense clearly, Attorney Balskas had an opportunity to review those things if he signs a protective order, and they could ask the court to lift the protective order if there was a basis to lift the protective order. So we weren't trying to hide the ball from him or hide him from having those. He could sign the protective order, and if after reviewing the materials had an objection to the protective order, clearly could raise that issue with the court. So it isn't a situation where we're not trying to provide the materials. We do the protective orders as a matter of course. They are routinely signed by almost every attorney in this county on a regular basis. This court is familiar with that process. So we're not attempting to hide any of that material from him. It's available to him. If he had signed the stipulation, he could have had the materials. He doesn't have to sign the stipulation on behalf of his client. That's fine. And we simply ask this court to enter a protective order before we turn over this sensitive material. You've got medical records of a crime victim. You've got an audio video recorded statement of a 7-year-old child. Those things are sensitive material. They're subject to protective orders and that are routinely signed in this county. And I think an order should be entered in this case on both of those. As for the discovery violation, I just simply think that doesn't exist here. We have tried to obtain this material as quickly as we could. We've turned it over to we're willing to turn it over to the defense if they had signed a stipulation, which chose not to do. But this material is still available, and we're 2 weeks out from the trial date at this point. We're talking about 43 pages of medical records. Also, Your Honor, I just wanted to clarify that. Obviously, Mr. Balskas doesn't know that, doesn't really have a way of knowing that because they chose not to sign the stipulation. But it's 43 pages of medical records. It's not an overwhelming or burdensome amount. And then obviously the child's statement as well. And there, he is correct if there's an error that it indicates that it's the victim's statement. It is not the victim's statement. It is a child's statement. It is often the standard form that we use indicates that it's the victim because it typically is, and that should have been changed.
Thank you. I have statute 908.8 right in front of me. It does just say 10 days before trial is the standard for filing the notice on that. And then it does not specify that that the child has to be a victim. It just says more generally statements of a child. And then I would note that based on the child's age, the court isn't even supposed to consider interests of justice in the analysis. So I do think that ruling is pretty straightforward. That a video statement of the 7-year-old child is admissible, and I also will order it sealed as well. That certainly means that Attorney Balskas reviews it so that he can be prepared for trial. If there is something in the video that is inadmissible evidence, then I would ask the parties to communicate that together. And if it needs an evidentiary ruling for a redaction of the video, then the court can rule on that. But I think the state has established all the standards for the audio, for entering the audio video visual recording of the 7-year-old child. And then as to the medical records, if I can just ask a clarifying question, DA Lizzie, they're the alleged victims' medical records?
That's correct, Your Honor.
Okay. And if I ordered them sealed today, would Attorney Belskis be able to get a copy of it today?
Yes, Your Honor.
Okay. So I am gonna grant the state's request as to the medical records also, that they are sealed. One thing I would point out is that we do have a constitutional amendment now passed last year for victim rights. So victims have enhanced rights on these cases, and not to mention that this is medical information that is protected by various federal and state laws. So I think it is reasonable to sign an order sealing the medical records as well. We are 13 days from trial. So I do consider that a long period of time in terms of being able to continuously prepare for a February 10th trial. I think that this case would be the #1 priority on February 10th, with Mr. Curry being in custody on a speedy trial. If the defense wants to file a motion to adjourn with a bond motion, you are free to do that leading up to February 10th. But it will remain on the calendar as scheduled now.
Okay, well, just Judge, I would point out too, is that the requirement under the statute is that the medical records be filed 40 days before the trial. That has not been done. I don't know why it wasn't done, but that, so we would be objecting to the medical records being introduced because of the non-compliance.
And what statute are you referring to?
Well, the statute that they said that they were intending to, they filed, I'll get the statute that I believe it's 90803 sub 6M, but I'd have to check.
That is correct, Your Honor. I looked at that notice. So there's two separate issues here. One is the motion for the protective order with respect to the medical records. I think that should be granted for the reasons that the court indicated, and that there should be a protective order in place, and then we can provide their medical records to Attorney Balskis. The statute that was cited with respect to the motion to introduce those medical records really deals with their automatic introduction without the need for a records custodian. So if the court denies the motion to introduce the medical records because they're not filed within the 40 days, that doesn't mean the information contained therein or the records themselves are not admissible. It merely means they're not admissible absent a records custodian or a medical provider who was involved. So there are alternative ways that the state could introduce those records and authenticate them and still have the content of the medical records admissible. So if the court chooses to deny the motion to introduce them without the records custodian, I think the records themselves still should be subject to a protective order, and then we can introduce them at trial through other means, either through a records custodian or they can be introduced through the medical provider who could verify the accuracy of those records.
I'm reading that statute right now, and that the statute is consistent with what the prosecutor said. So Attorney Belskis, it looks like the only remedy is to have a custodian of the record testify instead of them being self-authenticating. What, do you have any additional comment on it?
I think we also run into the problems of hearsay, things of that nature, in terms of the admissibility. But that is something that the state is going to have to basically try to, are going to have to deal with at the trial. Because I don't think that, especially The only problem that I see too is that, like I said, I don't know what the records are, and that we would probably have a right to get additional records of the victim in terms of, but I don't know until I get the records. That's part of the problem with what has happened here. Especially in light of the testimony at the preliminary hearing where the officer that was called by the state said she didn't get any medical treatment. So.
Well, you made a statement earlier on this case regarding the victim. So I obviously don't have any idea what the content of the medical records are, but I assume you want to review them for anything potentially exculpatory as well.
Yes.
Just on the issue of whether or not you would like a custodian to testify, though, about the records, or just enter them as a certified document.
Well, I would say that they have not complied with the statute, so they're going to have to find another way to get those admissible. That's our position.
Okay, if the defense doesn't agree to waive that requirement for the 40 days, then I think that according to the statute, the state would be required to call the custodian then. Anything additional, Attorney Belskis, to address today that you're aware of?
No, I don't believe so.
Okay. DA Lizay, anything to address?
Your Honor, does the court have copies of the proposed protective orders in these matters, both with respect to the CAC interview and the medical records?
I see a proposed protective order for the audio-visual recording. A proposed order to seal the audio-visual recording. I think those are the only two proposed orders, so you would need an additional one, yes.
Okay, if the court doesn't have a proposed protective order with respect to the medical records, we'll provide that to the court for signature.
Okay. And then, well, Mr. Curry's raising your hand. Did you want to speak with your lawyer privately, Mr. Curry?
For 1 second, please.
Okay. I am gonna have Bond continue. When we're completed with the hearing, I can put Attorney Belskis into a breakout room. I'm gonna set another court date on this case, if we can, next week.
So we don't
Oh,
have time to,
not yet, Mr. Curry, I'm scheduling it. How about Wednesday at 3:15? February 3rd, Attorney Belskis, what does your calendar look like?
That's fine.
Wednesday, February 3rd at 3:15. And then Bond continues. So we're off the record now, and I'll put Attorney Belskis in a breakout room. If you have time, Attorney Belskis, I don't want to assume you have time.
Yes, I have time.
I wanted to speak to him about this
That's
case in
what-
particular,
That's
So that
that's
we
what we're gonna do. Mr. Curry, that's what we're doing right now.
but the court is adjourned, isn't it?
Okay, if you can accept the prompt, then you can speak with your lawyer privately. Hi. Is it Judge Gill? Okay, 'cause it's difficult with the face mask, but.
Yes, it's, we know it's this month, so I just was making a visit up here today, wanted to stop in and say hi. Tried to connect with you a few times, but we've just been missing each other.
Sure, yeah. Do you want to talk in the jury room?
Sure.
Okay. Yeah, let me write this in. This isn't my normal courtroom, unfortunately.
No.
Heather, are you the person on the Galaxy A01? Is that Heather? Okay, I think the hearing is done. Just the two of them are in a breakout room, so. you
It's
can-
done? Awesome. Thank you. Have a good day.
Thank you.
Thank you.
Oh, she's good down there.
We have another case at 2 o'clock, so I brought you out of the breakout room.
Oh, okay. Okay. But it's not for me, right?
No, it's not, no.
Okay. 'Cause at the jail, they were like, oh, you've got another case. I'm like, news to me. All right. I will then, what I will do is with Mr. Curry, they're back. Just let him know that I will be stopping to see him probably tomorrow.
Okay. Oh, I think they moved him along already.
Okay.
Mike,
sounds good.
Mike, do you want us to put a copy of the CAC interview at our front desk?
Yeah, just let me know when it's done.
Okay.
All right, thanks.
Oh, Mr. Curry, your case is done.
That's what I just told her.
I don't know.
She said my case is done.
Yeah, the case is done, yeah.
Yeah.
Thank you.
Walk out of the room for one second.
Thank you.
Anna, you're up here.
We have 2 cases at 2 o'clock. We're working on getting the one at Oshkosh.
What's your name? Virginia?
And then it looks like this might be your client, Attorney O'Connell.
I'm looking, I don't see him yet.
They said is
YMA?
like they're bringing him in.
That doesn't mean just walk away. Locking that door.
Verify which room he's in, because we have 2 of them up right now. 2152. Oh, okay, yeah, those are the 2 rooms we have open. So it would be 20152.
So we have 151 and 142.
20151 or 20142. That would be 20152.
Attorney Stebbins, just determining which case will be quicker. What are we planning on doing on your case?
Thank you, Judge. Just scheduling, I can put the reasons for that on the record or explain it to you now, whatever you prefer.
Let's see if we can get your client real quick then. Well, on Mr. Johnson, he apparently is in a block where they're supposed to come to the area where where the video court are, and he hasn't reported there yet, so they're trying to find him now. Attorney O'Connell's case is a sentencing after revocation. So there's not a plea that needs to be done. So we'll start with that case, I guess, because we don't have Mr. Johnson.
Thank you.
This is Brown County case number 18 CF 877, State of Wisconsin versus Dustin Lee Fragina. The state is here by Assistant District Attorney David Lezay. Attorney Timothy O'Connell is here. Mr. Fragina is appearing by video conference from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney O'Connell, have you received a copy of the revocation summary?
We have, and we have no corrections.
DA Lezay, have you received a copy of it?
Yes, I have, Your Honor.
Attorney O'Connell, did you talk to your client about the video conference appearance?
Yes, he had indicated that he is fine with doing this by Zoom.
Okay. Mr. Fragina, have you been able to see us and hear us clearly so far?
Can you hear me?
I think the microphone is on that cord that you just picked up.
Here, 1 second, let's switch the microphone.
Okay.
All right, can you hear me now?
Yes, we can hear you very clearly now.
All right, sorry about this first time we're doing this.
Oh, it's okay. Are you able to hear and see us clearly?
Yeah, yes.
Okay. The microphone does give off static every time you touch it. So
All
I
right,
just
sorry, I'm just learning this. This is new to me.
okay. I would note that he's complying with the jail policy of wearing a mask. I think that is impeding our ability to completely understand him. Okay, but the important part is that my court reporter needs to hear everything that you're saying to be typed down, and then everybody here attending needs to be able to hear you also if you wanted to give a statement later in the hearing. When you held the microphone up to your mouth, we were able to hear you very clearly. But
All right, so basically like this.
yeah.
All right.
Yes.
All right.
Now it's very good right now. Yes.
All right.
Okay, so we'll continue at this point. Mr. Fragina, you do have a right to be present in person in the courtroom. We're doing as many of these hearings as we can because of the public health emergency. The easiest way to comply with public health guidelines is to do video conference appearances. Are you willing to waive your right to be present in the courtroom so that we can continue with this video conference appearance?
Yes, Your Honor.
And if it becomes necessary to talk with your lawyer privately, we can accommodate that with a breakout with this video conference procedure. Do you understand that?
Yes, Your Honor.
Have you had sufficient time to review the revocation summary with your lawyer?
I have, and I had some things I was going to toss by him, but I don't know if I can do that right now.
Okay, if you need to do that before we start, now is the time, yes.
May I?
Okay.
I have no idea what I'm doing.
Okay, if you could accept the prompt to go into the breakout room. And Mr. Fragina and Attorney O'Connell are now in the breakout room talking privately, and we'll go off the record until they're back.
Judge, I do have a 2:30 in-person hearing. Have we heard from the institution?
Yeah, they sent somebody to go get him now to bring him to the room. And they said it would be in one of these two rooms that we have up here. Okay. How much time do you think you need to complete the hearing by?
It's in the Marinette courthouse. I'm in our Marinette office, which is like a block away. So it's just if depends on how long the sentencing after revocation would take, I guess.
There's some movement on the screen, but they look like they're going a different way. Well, as long as you're able to wait, just let us know when you have to call the case and move on to the next one.
Thank you, Judge.
I suppose we could pick a court date right now if you're gonna be asking for a court date.
Yes, I am. Yeah, if we could, it's going to resolve. Attorney Potts, I'd set this over quick last time because I just needed to touch base with Attorney Potsky. I did do that, but she requested some verifying information. I imagine I would have that in a couple of weeks, but I would probably ask for a month just so that we don't come back under the same circumstances.
If you wanted to block a time for a plea and sentencing, it would be more like 2 months if that's okay. Friday, March 26th. (2 o'clock, 2:30, 3 o'clock, 3:30, 4 o'clock.
Let's do 3:30, please.
Okay.
And I don't know yet. It's going to depend on my follow-up with Attorney Potsky if it will be a joint rec to go forward with a plea and a sentencing. If it ends up just being a plea with one of the parties or both requesting a PSI, should I contact the court for an earlier hearing, or is that when the court's scheduling regardless?
No, we'll just keep it on for that time, no matter what.
Okay.
Is there anybody at Oshkosh Correctional that can hear us? Anybody at Oshkosh Correctional that can hear us? I guess not.
Judge, I don't know how comfortable the court is. He's going to be incarcerated until at least January of next year. I had spoken to him earlier this week about the status of the case. The court was willing to go on the record without him, just in light of the fact that we're kind of pushing it close to the time for me to be able to get over and be prepared for my hearing.
Okay. It's a non-victim case. So let's just call it then. Brown County case number 20 CF 327, State of Wisconsin versus Marcus Terrell Johnson. The state is here by District Attorney David Lazay. Attorney Scott Stebbins is here. Mr. Johnson is not here. We attempted to contact Oshkosh Correctional to get him on their video feed, and we haven't been able to successfully do that. And now Attorney Stebbins needs to move on to another hearing. Before we went on the record, Attorney Stebbins said he was going to ask for another date for a plea and sentencing anyway. We chose Friday, March 26th at 3:30 p.m. Is that accurate, Attorney Stebbins?
That is all accurate, Your Honor.
DA Lizzie, anything else to address?
No, Your Honor, thank you.
Although this looks like it's him right here.
No.
Okay, if you could unmute the device at Oshkosh Correctional, you could unmute the device. Are you able to hear us, Mr. Johnson? Give us a thumbs up if you can hear us. And he did give a thumbs up. Your lawyer is just asking for a new date on your case. The DA is here, the District Attorney David Lissay, Attorney Scott Stebbins is appearing on this video conference. That's who represents you. We now have Mr. Johnson appearing by video from Oshkosh. We picked the date Friday, March 26th at 3:30 for a potential plea and sentencing hearing. So your lawyer will reach out to you to prepare for that hearing. Understood, Mr. Johnson? Did you give a thumbs up again? If you could understand? Yep, and he gave a thumbs up again.
Your Honor, and now that he's here, just for the benefit of his knowledge, as I indicated off the record, I did have recent communication with Attorney Potsky. She responded to my counter proposal and basically wants some confirming information regarding the status of his revocation. So I need to provide that to her, but that's why we're adjourning.
Okay, thank you for the clarification. DA Lizzie, anything else?
No, Your Honor.
Attorney Stebbins, anything else?
No, Your Honor, thank you.
Okay, we'll be back again on March 26th at 3:30. And then that's all for today on Mr. Johnson's case. And thank you for getting him though. Thank you. And then we can go back on the record. That's all for Mr. Johnson. Thank you. This is Brown County case number 18 CF 877, State of Wisconsin versus Dustin Lee Fragina. The same appearances are here. Mr. Fragina and Attorney O'Connell are back after talking privately in a breakout room. Attorney O'Connell, are we ready to proceed at this time?
We are.
Okay, and then just confirming, Mr. Fragina, you can see me and hear me clearly again?
Yes, Your Honor.
Okay, excellent. DA Lizzie, what is the state's recommendation?
Your Honor, the state is recommending that the court impose a sentence relatively consistent with that of the Department of Corrections recommendation in this case. The SAR paperwork at DOC filed indicates a recommendation of 6 to 8 years of confinement on the 18 CF 877 case, followed by 5 to 6 years of extended supervision. With respect to 16 CF 944, DOC is recommending 4 years of initial confinement, followed by 3 to 4 years of extended supervision to run concurrent to 18 CF 877. I think that's a fair time frame for the recommendation in this case. I do think there needs to be a relatively substantial period of confinement at this point. I handled both of these cases. Mr. Fragina initially was convicted or was charged and then ultimately convicted with the enticement case, which was actually initially filed as using a computer to facilitate a child sex crime. It was a case that resulted from a law enforcement sting, and the initial charge was one of those that had a mandatory 5 years of initial confinement associated with it. However, we made the decision not to require him to enter a plea to that particular charge for several reasons. I mean, relatively young age, seemed to have some cognitive or mental health issues that were associated with his conduct, and ultimately entered a plea to enticement. In that, I believe that while he was on probation in the child enticement case, he actually self-disclosed the sexual assaults that he was ultimately convicted of in the 18 CF case. We did follow up with the crime victim in that case, met with them. Certainly the assaults happened as indicated, but because he had self-reported, he received really what I think to be a very lenient initial sentence in that case, or sentence was withheld and he was placed on probation. He was really given an opportunity. So in two separate, relatively significant child sex crimes, Mr. Fragina had the benefit of a withheld sentence and did not go to prison on cases where clearly he could have. And I think what's really disturbing here is that he's now demonstrated while on probation for these offenses that he does have some significant issues that I think are best addressed in a confined setting. He continues to violate the rules of his probation with respect to demonstrating interest in children sexually. He has access to the internet in ways that he should not, and I think that is more significant or more aggravated in a situation like this where the underlying offenses, he really did utilize the computer to facilitate those sex crimes in the first place. So ultimately, it's quite disturbing that he would continue to engage in that conduct while on probation for such significant offenses. I really think that confinement is the court's only option at this point, given the severity of the underlying offenses and then the demonstration on Mr. Brazina's part that he's not able to comply with the terms of probation. So while the sentence requested here by the department and by the state is a fairly sizable sentence, I think it's merited under all of these circumstances. So I would ask that the court essentially adopt the DOC recommendation and impose a sentence of somewhere in the neighborhood of 6 to 8 years of confinement, followed by 5 to 6 years of extended supervision, broken up in the ways that I've suggested between those two cases. With respect to sentence credit, on 18 CF 877, I think he would have 211 days credit as of today's date. So through yesterday, he would have the 211 days credit. He had 152 days of conditional time, plus 59 days since November 30th when he was taken into custody on the hold. And then on 16 CF 944, he should have 282 days of credit in that case. He had 222 days of pre-sentence credit, and then the 63 days, then I calculated that incorrectly. I apologize. He would then have 4 days less than that, 281 days of credit, 222 pre-sentence, plus the 59 days of credit since the hold. So I've got 281 on 16 CF 944 and 211 on 18 CF 877. Thank you, Your Honor.
Thank you. I would clarify that we're only here on the 18 CF 877 file. The 16 CF 944 file is in front of Judge Zakowski on February 1st, so next week. Did that change?
That explains why I calculated my credit incorrectly, because I had it through the 31st. I apologize.
Okay. Did that, so you knew that we were just here on one case today?
I did. I apologize. Just to clarify the recommendation, we're asking for concurrent sentences on those two in any event. And it doesn't change the 6 to 8 years recommendation that I have with respect to the 18 CF case, Your Honor.
Attorney O'Connell?
Your Honor, the ultimate question is what sentence to impose. On one hand, we understand these are serious counts, and those last few months of revocation haven't been the greatest. However, there have been a number of mitigating factors. Dustin, he's 28 years old, and other than the two cases that are in front of the court, his record is nothing. Looking in CCAP, I don't see anything else. He's been working the last 2.5 years at Aerocast in Shawano. Apparently, he's a good worker. To his credit, he's pled guilty and then admitted his fault to the agent to get him to today for sentencing purposes. I do want to point out in the revocation summary, it indicates he violated his supervision rule of not informing his agent that he was pursuing a relationship with another individual. As for that violation, I do want to point out that the individual in issue was a 30-year-old. I wanted to highlight this for two reasons. First, so that there was no misunderstanding that he was seeking a relationship with a minor. But second, obviously, if the rule is that you have to get permission first, he should have obtained permission first. However, with that being said, I think if he finds someone his age to get in a relationship with, that is probably the best thing for him. In reviewing in addition to reviewing the revocation summary, Dustin was put on probation in the 2016 case in February of 2017, and the 2018 case in September 2018. During that time, for the most part, up until his last few months, starting in September 2019, he did good. He obtained his GED. He earned himself a job. He took numerous sex offender classes. Then in August of 2020, he moved from living with his parents into his own apartment, obtained too much independence, and then things went downward from there. Obviously, it's unfortunate what happened, why we are here now. I asked Dustin what happened, why he was doing so well, and then it fell apart. He indicated that he could do well when he had a chaperone. I believe chaperone is the word he used, but essentially someone living with him and looking after him. He indicated while living with his parents and getting that supervision, he was busy and he didn't have any temptation. It appears the probation, however, moved too quickly and gave him too much freedom before he was ready. Now, when I say that, I know Dustin is not pointing any finger at anyone else. Ultimately, he knows the buck stops with him. However, I point this out because it shows he can be successful out on the street if he's living with others, such as his parents, but he won't be able to live independently for a while. As for an appropriate sentence, Dustin doesn't have any delusions that this court will be giving him time served, and we aren't asking for that. The agent is recommending 6 to 8 in, followed by 5 to 6 out. This court's been provided a number of mitigating factors as well as some information that Dustin can be successful out on the street with heavy supervision. As a result, we are asking the court to consider to reduce the amount of in time that the agent is recommending and increase the amount of out time. So ultimately, we are asking for 2 to 6 in, and then to add some more time to the ES portion of the sentence. As for the credit, we agree with the state, and I believe that 211 days is coming from on the revocation summary from October 28, 2018 to March 28, 2018. That would be 152 days credit. And then he was put on a hold from November 30th up until today. That's 59 more days, and that comes to 211. However, when I researched this case, it looks like, and I believe I got this from the Brown County Jail records, on June 13, 2017, he was arrested specifically for this case, and he was released 2 days, or it was on June 15, 2017, he was then released. So we would ask for the additional 3 more days, which would come out to 214 days credit. That's all I have.
Thank you. Mr. Fragina, now is your opportunity to address the court before I issue the sentence, if you choose to do so. Did you have anything you wanted to say?
Can you still hear me? I just want to make sure you guys can hear yourself.
Yes, we can hear you well, yeah.
All right. I get what Mr. Lissay is saying, and I also get what my lawyers are saying, my attorney. I just know that what I did was wrong, and I have full regret for it. And I want you to be aware of that. I am not pointing fingers at no one because ultimately it leads to me, like my attorney pointed out. But I just want to tell you, both of you, that I believe I can be a successful person. I believe, working at Aerocast showed me a lot where I didn't have that. Like, I grew up a lot with a lot of things, with getting, all of these accomplishments that I did in the 3 years of time that I was on probation. And I can understand, where you guys are coming from in this. I get that. It's just, I ain't gonna lie, I'm scared. And I understand, you guys got to do what you got to do. I just was hoping to let the court know that I am very remorseful of my actions. And I was hoping that could be put into consideration. That's all I got, Your Honor.
Thank you. When I issue a sentence, in this case, it's after a probation revocation, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, the character of the defendant, and deterrence of others, and then apply the Galleon sentencing factors to those sentencing objectives. All of the sentencing objectives seem to apply to this case based on the conviction that we're here for today, which is a significant offense. Protection of the public and gravity of the offense are certainly a sentencing objective that apply here. The rehabilitative needs of the defendant apply, as he has had treatment during the probation sentence. Character of the defendant also applies, and we have positive information about his character in the revocation summary, and we have negative information about Mr. Frugina in the revocation summary. And then deterrence of others is obviously a significant factor and a significant objective when we're talking about offenses against children. And then I would also point out that punishing the defendant, I think, is an objective at this point as well, because of what he's been convicted of and his performance while on probation. So all of those things are relevant objectives in this case here today. The Department of Corrections is recommending 6 to 8 years of initial confinement and 5 to 6 years of extended supervision. The state is making a recommendation consistent with that. And then the defense is recommending less initial confinement time of 2 to 6 years and then longer extended supervision time. The positive factors that are outlined in the revocation summary are that it looks like he did complete some treatment programming, which is positive. He did obtain a high school equivalency degree. He's 28 years old. He does have an employment history, and then he moved into an independent living situation. And he also says here today in court that he does regret his actions. But the problem in this case is that the actions don't show an ability to apply anything that he may have learned in treatment, because the violation summaries that's outlined, the 7 items, I mean, that really reflects negatively on Mr. Frugina's character, that he has 2 prior sex offenses that involve children, but he's still participating in the same type of high risk behavior that got him in trouble in those 2 cases in the first place. In the nature of the offense, in the case we're here sentencing on today, Mr. Frugina was 24 years old at the time of the offense, and then the victim was about 14 or 15 years old based on the time period that's given in the criminal complaint. He admitted to having sexual contact with the victim in the form of touching the victim's penis and watching the victim touch their own penis. And then he was given a pretty substantial opportunity for probation after serving some jail time. But like I said, the same type of behavior has continued. So although all of these sentencing objectives are relevant in this case, I do believe that protection of the public and gravity of the offense are the overwhelming most important to this sentence here today after the performance on probation. So I'm going to sentence Mr. Frugina to 8 years of initial confinement and 6 years of extended supervision. So that'll be a 14-year sentence in the Wisconsin state prison system. A compass evaluation and AODA assessment will be required. Follow through with any treatment recommendations. Full-time employment or school. No contact with the victim, ZMS. No contact with anyone. No unsupervised contact with anyone under the age of 18. And then any financial obligations that he still has would be due during the period of extended supervision. In terms of the credit, it sounds like there's an additional 3 days that Attorney O'Connell identified. DA Lizzie, do you have a position on that?
I didn't look that up, but that sounds correct based on my recollection, so I don't have any objection to those additional 3 days.
Okay, so it'd be 214 days credit. What about eligibility for programming? Did the state want to take a position on that?
I'm not sure, given the nature of the sexual assault offense, if he's eligible for any of that programming. I think the sexual assault probably doesn't allow him to be to qualify for those. If it does, I would ask that if the court is inclined to allow challenge incarceration or earned release program, that the court indicates that he serve at least a minimal amount of time of initial confinement prior to eligibility.
Attorney O'Connell, any comment from you?
Your Honor, I don't believe under the statute, I'm looking at it 973.01 sub 3G and sub 3M. I don't believe he's eligible for either of the ERP programs.
I'm not going to find him eligible for the programs then. DA Lizzie, anything additional from you?
No, Your Honor.
Attorney O'Connell, anything additional from your perspective?
No, Your Honor.
I did. Yeah. Okay, then that's all for today. And we have a case at 2:30 that we're going to call next.
Great. I believe we're done.
Yes, that's all for Mr. Frazina, yes.
All right, I
Thank
gotta make sure the guard knows.
Yeah,
Thank you.
I'll be walking the Fox Pod for your next one.
All right.
Thank you.
Right.
Dave, are you handling Jordan?
Yes, I am.
I got 128 days on count 1 and then 108 on 2 and 3.
I'm close to that, but I had 113 on count 1 and 100 on count 2 and 3. Did I miss something?
I can quickly add it up.
Let me see if I can pull it up. Yeah, it was weird. She had they were like giving her a hold. They gave her credit for a hold on counts 2 and 3 while she was serving the conditional time on count 1. I didn't understand that on the summary.
Oh yeah, I see that. What the heck? Yeah, the one looks like a 3-day hold, huh?
Yeah.
Well,
she had like a 3-day hold, which was like before the conditional time, but then once the conditional time started, they gave her another like 8 days for that.
Oh, that's where I'm screwed up. Yeah.
So I don't.
Yeah, then that would be double counting then for that. That's.
Did you have 108 for counts 2 and 3?
Yeah.
Yeah, I think that's where I had. So I had 100 for counts 2 and 3. And then what did you have for count 1?
128.
Okay, I had 113. I don't know where. Did I? Is that the same thing, like the double? You gave her
maybe,
the
huh?
hold and the.
Yeah, maybe that's what it was.
2 plus 21 plus.
All right, we're here.
Thank you.
Get it up to.
And 76, right? 221 plus 76.
2 21.
And then
The revocation summary I have is like redacted in some places with black.
Yeah,
Yeah, that was a weird one for sure.
never
Ever
seen
seen
that.
that before? Did you have an issue with that, Attorney Richards?
No.
Okay. So I didn't do that, so I don't know who did. I don't even know who did that. Are we ready to call it, Attorney Richards?
Yeah.
This is Brown County case number 20 CF 106, State of Wisconsin versus Sequoia Chenille Jordan. The state is here by District Attorney David Lassay. Attorney Steve Richards is here. Ms. Jordan is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Richards, have you received a copy of the revocation summary?
I have, Judge. I note there's no corrections.
DA Lassay, have you received a copy?
Yes, Your Honor.
And Attorney Richards, have you talked about the video conference appearance with your client?
I have, and she's willing to waive that and appear as she is now.
Ms. Jordan, are you able to see me and hear me clearly right now?
Yes.
Okay, we can see you and hear you clearly as well.
Okay.
Are you willing to waive your right to be present in person so that we can do the hearing by video conference instead?
Yes.
Okay, if at some point you can't hear us or see us, make sure you gesture to us right away. Wave your arms around, do something.
Okay.
If you need to speak privately, if that becomes necessary with your lawyer at some point, we can accommodate that with this video conference procedure. Understood?
Yeah.
Okay. DA Lassay, what is the state's recommendation?
Your Honor, again, the state in this case would ask that the court essentially follow the recommendation of the Department of Corrections. Here, their request is for 9 months jail on each of the Class A felonies, and then 60 days jail on the, not felonies, misdemeanors, the Class A misdemeanors, and then 60 days on the disorderly conduct, and all of those to run concurrent. I think that's appropriate in this instance as well. When I look at the underlying crimes, they are violent in nature. There's a battery count, obviously, that the court is to consider. And then when you look at the new offenses, the new allegations also involve impairment followed by violent conduct. So I think the new conduct here is indicative of her character and then indicative of the danger that she presents to the public if she's not able to get those issues under control, particularly the substance abuse and the anger issues and the mental health issues that all seem to be quite apparent here. Unfortunately, during the course of probation, she wasn't able to get those under control, at least not fully, and then it resulted in new conduct that's somewhat consistent with the underlying conduct. So I think the recommendation of the department for the 9 months jail on each of those Class A misdemeanors and the 60 days jail on count 3, all to run concurrent, seems appropriate here. I believe that with respect to credit, so kind of going through this again, I have 115 days with respect to count 1 as I re-add this, and then 100 days with respect to count 2 and 3 is what I've got for credit. And then I would ask that the court convert any unpaid financial obligation to a civil judgment.
Attorney Richards?
Thank you, Judge. I did the revocation order and warrant on the sentence credit was a little bit convoluted. I recalculated and I concur with those calculations. That being said, Judge, Ms. Jordan is 28 years old. The state is correct in identifying that there's some mental health issues here that are present that have been really somewhat unaddressed, and I think have led to the problems that Ms. Jordan has had. My understanding that she may have one prior conviction, maybe a theft, if I'm not mistaken. That's just what my client had indicated to me. I didn't double check that. She does have 3 children, ages 2, 6, and 8. Currently, she's working with a CPS worker, and there's a CHIPS proceeding, as I understand it. She did receive a GED from NWTC. She was diagnosed schizophrenia back around age 12. Despite that, she was not a participant in special education due to the lack of apparently the accommodations her sister was, but she wasn't, and she had struggled during her years in education growing up. She plans on going to either the Golden House or the House of Hope when she's out of custody. She is currently homeless. Her mother had passed away in a drunk driving accident when she was 9 years old. She was then raised by her aunt, and just a few years ago, her aunt had passed away. And if you read the underlying complaint, it appears that at that particular time, her sister had died, and then she was going through some trauma then. Her father has a mental health history, so it is prevalent in the family. She resorted to drinking to self-medicate when she wasn't on her prescribed medication, and she did have difficulty at times obtaining that. So she indicated to me that she's mindful of the fact, or aware of the fact, that there's a mental health court. It's not available here because she's revoked off these, but certainly I think it may be something that would be suitable for her going forward with the issues she had with the new charges. Apparently they're still looking for an attorney, and so she's at the initial stages in those proceedings. So I think if she does get into something like that, that would be quite beneficial, not only to her, but then society. It seems as though that, trying to be on the street and
she is being moved at the jail. Let's make sure that she can continue to hear us.
right.
Ms. Jordan,
I'll let you go, Judge.
Ms. Jordan, are you able to continue to hear us? I think it actually froze when she arrived. Just for the record, everything was fine until about the last sentence that Attorney Richards was saying in his argument. The jail staff moved Ms. Jordan to a different room, which all transpired over about 5 to 10 seconds. And now the screen is frozen once she went into that new room. So we'll wait a second to see if the screen unfreezes.
Okay, I think it's like froze or glitching.
Ms. Jordan, can you hear us? Okay, it looks like it's moving now. Ms. Jordan, can you confirm that you can hear us? Can you hear us?
No, can you pause for a second?
Yeah, she's better off in wherever she was previous to that, because it doesn't seem like it's working.
Okay, let's go off the record until we get the audio video sorted out.
And Dave, on that, what you recommended 9, 9, and 60, the same as the report? Okay.
Okay, Ms. Jordan, can you hear us now?
Okay.
Can you hear?
Yes.
Okay. Are you okay? That does look
Yeah.
much better too. It's still a little
We're
bit.
still switching tablets.
Okay. Should we continue, or is she
Hey,
gonna?
you're on. Can you let me in?
Oh, I see. Yeah, I see what
We
you're doing.
switched tablets. Can you let me in?
Okay.
Oh, dang.
Okay. Yeah, I want to turn one off.
Sorry, just a minute.
Okay.
Sorry, Your Honor.
Okay, yeah, that looks better.
Okay.
Okay, Ms. Jordan, are you able to hear us now?
Yeah.
We'll go back on the record. The jail gave a different device to Ms. Jordan, and now she's coming in clear again. So Attorney Richards, do you want to continue?
Thank you, Your Honor. As I was indicating that she has the new charges and she's mindful of the fact that the mental health court is available, and I think it's something that would be appropriate for her to get into, have some more close monitoring and try to help her with these situations. Somebody with schizophrenia and other sorted mental health issues, it's not her place to try to do this on the street in a homeless situation. It's gonna lead to more trouble for her, and unfortunately, all too often in the criminal justice system, somebody loses control after drinking and has these type of issues. The only way that unfortunately those are addressed in many cases is the punishment and trying rehabilitation, like we did on supervision. Unfortunately, I don't think she had the necessary tools and really the foundation to succeed on that. So it's not surprising that she ended up where she did. You know, in the allegations where it indicated that there was the retail theft at Walmart and where they found her with another companion at a restaurant, she was just taking things to survive, food and some other clothing items. So wasn't something where she's supporting a drug habit, but simply that somebody who has no resources and unfortunately resorted to that type of conduct. That being said, we're recommending, since I believe she has a limited prior record, in this case, 5 months on count 1 and count 2 and 60 days on count 3 to run concurrently. Thank you, Your Honor.
Judge, I don't say this to contradict Attorney Richards or to create any issues. I do want to clarify the prior record for the court. I should have put that on the record. She does in 2018 have a OWI second with a minor in the vehicle. In 2018, she's got a domestic violence battery conviction. In 2018, she has an OWI first with a minor in the vehicle. And then in 2012, she did have a retail theft, and in 2010, a disorderly conduct.
Thank you. Attorney Richards, anything else?
No, Your Honor.
Okay, thank you. Then Ms. Jordan, I'll go to you. Now is your opportunity to address the court before I issue a sentence, if you choose to do so.
I wrote a letter.
Okay, if you want to just read the letter, you are free to just read the letter.
Okay.
Make sure you read it slowly. Make sure you read it slowly, though. We do have a court reporter typing everything down.
Okay. I've struggled with my mental health since adolescence. So being homeless, I was constantly in survival mode on the streets. Honestly, being incarcerated has been a blessing in disguise because I had a place to eat, sleep, and get stable on my medication. Unfortunately, I recently found out my 8-year-old daughter was sexually assaulted by a family member's boyfriend, who she's temporarily placed with, which has caused me to put things into perspective, realize that jail cannot offer me the things I need in protecting my children or taking care of my mental health. Today, I hold myself accountable for my actions so that I can bring my family back together. I can't change a single minute of yesterday, but I can take charge of the future. I need my kids as much as they need me. Thank you.
Thank you. When the court considers sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, character of the defendant, and deterrence of others. Then apply the Galleon sentencing factors to those sentencing objectives. The Department of Corrections and the DA's office is recommending 9 months jail with concurrent sentences on each count. And then the defense is recommending 5 months jail with concurrent time on each count. Ms. Jordan does have a record before this incident that was just highlighted by the prosecutor. I think it's pretty clear that a combination of mental health issues and substance abuse is contributing significantly to the criminal behavior that Ms. Jordan has participated in. She's 28 years old. I think it was 3 children that she has. She did obtain an equivalency degree, which is certainly a positive factor. And the community has sympathy for individuals who suffer from mental illness, but the community also wants to deter criminal behavior in the community, particularly when it does involve some level of violence, like it did in this case, where she's convicted of 2 battery counts and a disorderly conduct count. And then I think this is a situation where, as is often the case with mental illness, when you're consuming street drugs and alcohol, it just amplifies the mental illness and makes it much, much worse. And that's led to the criminal behavior by Ms. Jordan. When I did consider her words here today, I guess I'll just say I hope you don't give up on treatment. This case is going to be over with a straight jail sentence here today. There's not going to be any probation on this case. You might have a case that's pending, but I hope you still continue to find out what resources are available to you and continue to try to take advantage of them in the community to help you straighten out your life.
Absolutely.
When I consider the sentence, I will sentence Ms. Jordan to 8 months of jail on count 1 and count 2 concurrent, and then on count 3, 90 days jail concurrent as well. So the total sentence will be 8 months jail. Any financial obligations will be amended to a civil judgment at this point. And then the jail credit was 115 days on count 1. And then there's a different number for the counts 2 and 3.
Yes, Judge, 100 days on each of those counts.
Okay, then 100 days credit on count 2 and count 3. Anything additional from the state?
Thank you.
Attorney Richards, anything else from your perspective?
No, Your Honor, thank you.
Anything else? That would be with Huber in good time.
Thank you.
And then that's all for today. Good luck to you, Ms. Jordan. And you can tell me after your case is over. Thank you.
Okay, it's over.
We are going to take a 5-minute break right now. There's one case at 3 o'clock. We'll call that case in 5 minutes.
Thank you.
Oshkosh Correctional. I'm not sure. This is Brown County. I'm Judge Bo Lejoyce. Who do you have with you?
Mr. Washington.
Okay, I see Mr. Washington at Oshkosh Correctional. I think we might just not have logged off. I don't know if this is the right place for him. So would you like me to just terminate the feed? You're gonna do it? Okay. Okay.
Sorry about the squeal before.
Oh, no problem. It worked out well. Just waiting for the prosecutor to come back and then we can call the case.
Sorry, I'm here, Your Honor.
This is Brown County case numbers 20 CF 365 and 20 CF 1112. They're both state of Wisconsin versus Brandon Terrell Washington. The state is here by District Attorney David Lassay. Mr. Washington is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. We're here today on several motions that Mr. Washington filed. I believe I denied one of his motion to dismiss based on the information. And I think it simply was Mr. Washington didn't have the accurate date of when the information was filed in this case. And I know he is limited on the information he has access to being in custody. But I did give that a thorough review of the court's file, and I did believe that the court's file conclusively showed that the information was properly filed. Does the DA's office have anything to add to that?
Oh, I reviewed the court's decision in that regard. I don't know. I believe that the state had moved to file an amended information, and we filed that with a motion for leave to amend the information. And it's possible that the date Mr. Washington included in his motion was the date of the proposed amended information. Because I think he indicated it was like December of 2020, which would have been around the time frame that we filed our motion.
Yes, Your Honor, it was just it was miscommunication between me and the clerk office. I did get some incorrect information from them, so or I misheard, or my fiance misheard the information. So that was on my behalf. I apologize about that.
Okay, no problem. Then we will move on to the other issues. And I think I sent a letter to Mr. Washington. I think it was this case. Yes, on January 22nd. One of your motions was a motion to suppress. I think there were two different motions to suppress based on the search warrant process. And then I sent you a letter. I guess, did you receive the letter I sent?
I just got it at 3 o'clock this morning. I did go over it, Your Honor. I looked into to the case number that you gave me, I mean, I believe I thought you granted me a hearing, which was on the 24th of November, and it was rescheduled due to me and the DA was supposed to be working upon the agreement. I didn't get a note. I wasn't told then that I had to bring documents, you know, for those dates or anything, or else I would have had them sent to you, Your Honor. I read the case, and the case that you gave me, 97130, it doesn't state certainly that I have to prescribe these documents. It just tells me that I have to give a brief description and my motions, you know, and I gave that description, but I wasn't aware of having to provide documents of those dates.
Okay.
I would have been sent to you.
Well, it sounds like you read the letter. I guess my point was that I don't have any of the police reports. I don't have any reports at all. So I need.
All right. Well, I'm not asking for the police reports.
Well, I'm saying when you file a motion and state with particularity what you're asking for, particularly something that seems like it'd be in a report somewhere that I would need to be provided with that information because I don't automatically receive it. And I wasn't expecting you to bring it here or have it filed by today. I knew the chances that you wouldn't receive the letter before today were low. So just letting you know that. DA Lizzie, any comment on anything at this point?
I think I have some of the same concerns. I'm not really sure what the motion to suppress is based on, and I can tell you the state does not have witnesses present today because I'm not entirely understanding the nature of the motions. I do know one of the things that the defendant had indicated in his correspondence back and forth with the court was that he wanted these recordings from the search warrant. And I just wanted to clarify, I mean, there's two different processes that are outlined in the search warrant statute. And one of the processes is for an oral recitation to the judge who signs the warrant. In that instance, there would be a recording of the oral statement. It appears that these search warrants are all based upon a sworn affidavit of the law enforcement officer, which would not require any sort of recording or any oral information from the officer. These warrants were instead based upon the information contained in the sworn affidavit.
Okay, I would like to, I will object to that because also as well in 96812, 3D clearly states if the caller, if the call informs, if the judge is informed by a phone call that a search warrant is being requested, then the officers have to be sworn under oath, recorded testimony. So the affidavit, the affidavit is a support of the search warrant, but when you have to do it under the statute of 3D, calling the judge requires sworn testimony to be recorded, not just a affidavit to be signed and be sworn in over the phone. But this had to be recorded due to the fact that it's under the option of 3D. You recording you calling to request a search warrant. So at that point, you now have to go under the 3D statute of oral testimony because of the fact that it's not done. It's an out of court search warrant. It's not this is not done in court. This is done over the phone now.
Which warrant do you indicate was done on the phone and not via affidavit?
The one that was issued at 10:17 that night on 3/05.
And I don't even think that's accurate information. Even if it's done over the phone, they can send an affidavit to the judge and the judge just reviews the affidavit. So the law enforcement doesn't have to do both of those things. They just have to do one or the other. That's very clearly stated in that statute. I don't think that this is even a motion that's filed. I think you just sent a request asking for the recording. And I assume if law enforcement had taken a recording, they would have given it to the DA's office and the DA's office would have provided it to Mr. Washington by now, correct?
Correct. We don't have such a recording because as the court indicated, that's not required. It's one or the other. If there had been sworn testimony taken orally rather than basing the warrant on a written affidavit, then there would be a recording. But because these warrants were all based on affidavit, there is no recording to turn over.
And that's what the statute is, Mr. Washington. They have to do an affidavit or testimony that's recorded. not
Even
both.
if it's done, even if the warrant is requested over the phone, you don't have to do it.
Correct.
You don't have to do it. It don't have to be recorded.
Correct.
So what's the point of sub 3D saying that it have to be recorded then?
You're not listening, and I'm just going to say it one more time. They need to either get an affidavit to the judge, or there can be testimony with a recording. Not both. Law enforcement's required to do one or the other, and that's really clearly stated in that statute that I sent you in the letter. And I know you just received the letter, so I don't think you filed a motion on this, but to the effect that you are making that motion, I'm going to deny the motion based on for suppression of the search warrant based on the recording. I just think it's a misunderstanding of the law on Mr. Washington's part that law enforcement is required to record the communication when it's based on an affidavit. That's just an incorrect reading of the statute. So then there's a second part of this with the dates of when the search warrant was obtained and when it was returned, I believe. And that was the one where in my letter I'm asking for where that's cited in police reports. How do you know those dates?
The second part of the search warrant is it's not for the returns. This is for the illegal search of the jail property. The jail property was searched without a warrant. And this is in the affidavits. It clearly states that it's in the affidavits. I have right here, Officer Roman clearly states that him and Deputy Zimmer came up to the jail on March 5th as he was doing a follow-up and was allowed access to the defendants to my property. And then he came and asked me for consent. I denied him consent to search the property. He took the credit cards out the property. He scanned the credit cards. He went and wrote a search warrant up using the information from the credit cards. That's not a legal search. And there was no probable cause of searching my property due to a follow-up.
Okay, I don't think that's a accurate statement of the law either. Let me give the District Attorney Lizzie the opportunity to review the file and respond if he wants to for today's purposes.
Could, Your Honor, do you have the date of the particular motion that addresses this issue?
I see it discussed. It's filed November 19th, 2020. Looks like document 36, and it might have been scanned in again as document 37.
My apologies. I'm just looking for that now. And that's in 20 CF 1112.
Correct.
Yes, I think that's the file we're talking about. Yes.
Right. I don't see that document in our file. There's unfortunately a lot of documents in the state's file on that issue.
It is dated November 19th, 2020. That's when it was that's when it was filed, scanned in and filed. It's labeled motion to suppress.
I think I found it now, Your Honor. And it's document 36?
Yes. I guess, are you the owner of the Minnesota ID?
Yes.
So that Minnesota ID you referred to as your ID?
You say what?
Okay, I understand now. DA Lizzie, I'll go back to you when you're ready.
Sure. I'm just trying to, I need to pull up Investigator Ernstein's details. I mean, first of all, I mean, my initial thought would be that this custody of the Brown County Jail, it's property that Brown County Jail is holding. Investigator Ernstein is a Brown County Sheriff's deputy. I frankly don't think he actually needs a search warrant to search property that's at the Brown County Jail.
Oh, he definitely do.
Oh, we can only talk one at a time, so let the prosecutor finish. I'll give you sufficient opportunity to talk.
Okay, sorry.
I mean, as I indicated, Your Honor, it's property that's been seized from the defendant's person at that point in time, and is in custody at the Brown County Jail. I don't know why he would need anything more than probable cause to take a look at that, and I think he certainly did have probable cause to look through the defendant's property, given the information that he had at his disposal at that time. If that is the motion that the court wishes to hear, I would ask that we schedule that and have the opportunity to have Investigator Ernstein present for that motion, and we can talk about what information he had at that time when he did that. I'm just trying to nail down what it is that the defendant's motions dealt with, and if his concern is Deputy Ernstein's search of the property that was in the custody of the Brown County Jail on March 5th, I think that properly tailors the motion for the state so that we know what it is that the defendant is disputing.
So, Mr. Washington, do you have the motion in front of you? Your motion in front of you?
Yes, I do have a motion in front of me.
Okay, there's paragraph 1, and it says, don't give me any more details than you have in this paragraph. There's a Minnesota photo ID and 2 Visa debit cards. Are those the only 2 items that were taken from your jail? And maybe 3 keys?
The iPhone, it wasn't taken. The point is that he didn't seize the property right then and there. From my knowledge, he just took the credit cards and he scanned the credit cards, because it says right here, after he viewed me, he said, I further investigated the credit cards, and he scanned them and found that there was contained information that does not the regular information on the credit cards.
Okay, and I see one problem right away, that in your motion, it says Visa debit card in the name of Wendell McKinney. If that's not your debit card and not your name, then you might not have standing to challenge a search of it or seizure of it.
Okay, well, he searched my debit card as well in my Minnesota ID. He scanned my property still without a search warrant. He authored a search warrant, and I would like to argue the State versus Chadwick, where his property was seized. The Supreme Court overturned the decision and dismissed the evidence, suppressed the evidence due to the fact that his property was seized at an arrest at his car. They didn't search it at the scene. They took him in, came back later on and searched his luggage, which was at the jail property as well. And it was overturned due to the fact that the officer should have had gotten a search warrant, because it wasn't justified at the time of the arrest for the search. These debit cards was at the house when Deputy Zimmer came and searched the house, and he didn't take it into custody. He left it. He put it in my property. So it was determined that it should have been a search warrant if you're going to come back and search these same debit cards.
And what was the name of the case you said? The court reporter didn't get it.
State versus Chadwick.
Chadwick?
Yes.
Okay.
And it was real because the police had full custody of the luggage, and there was no way for the inmate to come and destroy the property or get a weapon or anything. So it was justified that the police should have had gotten a search warrant in order to search this property. There was a preservation letter as well that I have. A preservation letter was wrote up to hold the property so he can go and get a search warrant for the property. So there was no reason for him to search this property if you have no way that nobody can get my property or anything. My property was on hold, and I was sitting on revocation until July 4th. And this happened in March.
DA Lizzie, any additional comment?
Just that, again, Your Honor, I wasn't really particularly aware of what specifically that was the subject of this motion, and I wanted to have the opportunity to review that before going forward. I think we certainly could call Detective Ehrenstein and have him address the specific issues at a motion hearing if the concern is that particular property that was taken from the defendant from the jail.
Is the state sufficiently, do you consider the state sufficiently on notice then, or would you like Mr. Washington to file something else in writing?
I'm just a little unclear. There are a number of things from the search warrant on March 5th that were searched by Deputy Ehrenstein, and
Right.
Those are clearly listed. I don't know the locations of those things. So if Mr.
That was in my stored property.
If Mr. Washington could just clarify specifically which items he is objecting to, then I think the state would be prepared to address those at a motion hearing with Detective Ehrenstein.
1 second, I will let you know right away. I'm objecting to the Minnesota identification card and the Visa debit card that displayed my name, Brandon Washington. The credit card number 4403-9324-0630-1365. Those two was
Mr. Washington, I'm sorry, could you slow down and repeat the number of that card for me?
Yes, 4403.
Okay.
9324 0630 1365.
365, and that's the card in your name.
Correct.
So I'm asking the prosecutor if they know. So in this case, the officer took the ID card and the 2 debit cards and then did something electronically with them and put them back.
I doubt it. So I'm trying to clarify. So it's not, there's not like a forensic analysis that they would do with those other than look at them.
I'm reading right
potentially
here.
take the numbers, right? He wouldn't scan them. He would potentially then, if he needed to use that information in order to obtain a subsequent search warrant to get or subpoena to get the information from the companies, it's possible that he would have done that.
I'm right here reading the incident report of our Sergeant Roman, and he clearly states that after speaking with me, he scanned the cards, and then even in the search warrant, if you look in the search warrant, he uses the information from the cards that he scanned on my property, not to subpoena banks. He used that information to obtain the search warrant to get the credit cards on my cell phone. He used that information that he got from the cards to get a search warrant.
And then the search of the cell phone that after obtaining the search warrant.
Yeah, he after he got the search warrant to get the cell phone, he went and he authored the search warrant to search the cell phone and the Dell laptop computer. So then he got a search warrant for the computer and the 3 cell phones. Because he obtained 2 more cell phones from the house. But those are, I was asking because it was an untimely search of the Dell laptop computer. I had a forensics report where it was examined 6 days later.
Okay, that's a separate issue, and let's move to that one. The timing of the search, I think Mr. Washington filed a motion on. I'm trying to find what document that is. I think that's document 37. Also filed November 19th. And he pointed out, he asserted a statute that gives a 5-day requirement and says that it actually took place in 6 days in violation of that statute.
Mhm.
And that was the one where it was the subject of my letter asking you for documents verifying those dates. But you don't need to do that right now.
Oh, okay. I'll say I have the only thing I have is the examination of the Dell laptop, which states the date that it was examined.
Okay, so that's a separate issue. Okay. And then I think that covers all of the issues.
Yeah, for the search warrants, yes. I also had a motion in for the double jeopardy as well. That's a separate, another issue that it was filed back October. Yes, I got the exact date.
Okay, I see that one. That one's filed October 16th. Document number 32. Let me read it real quickly to refresh my recollection. And I think this is basically a multiplicity objection, that he's saying multiple charges of the same offense. He's being charged with a conspiracy to commit inappropriate personal identifying information. And then the other counts in the case are multiplicitous. What does that have to do with the search warrant, Mr. Washington?
Oh, that don't have anything to do with the search warrant. I was just saying that was a separate issue, Your Honor.
Okay. And I think for that one, I think the court can just simply read the criminal complaint and determine if it's multiplicitous or not. Anything that we're missing, Mr. Washington, that you filed?
Can you repeat that, Your Honor?
Anything else that we haven't addressed yet that you've already filed?
No, I believe we addressed everything.
I think the only time between now and the trial date where I would have sufficient time would be Thursday, February 4th. I have mental health cases in the afternoon starting at 1:30. So we could schedule this at 3:30 and hope that my mental health cases conclude before then. Sometimes they do, sometimes they don't. DA, say, what do you think about that time?
That should be fine as long as Sergeant Aaronstein is available on that date. I'll have to confirm with that. I'll do that right away today to see if he's available on that date.
Okay, Thursday, February 4th at 3:30. The trial date, I think, is February 10th. There is one case where the accused is in custody on a speedy trial demand. That would be the top priority. There are 3 cases total that are on the calendar. Anything additional from the state for today's purposes?
I know, Mr. Washington, that you and the assigned attorney on this case, Ms. Lemko, had spoken a little bit in a breakout room the last time we were at this hearing regarding a possible resolution. I know she's supposed to get you some information, and I don't know that she's gotten you a specific offer yet. If you are still interested in having a conversation with her or exploring the offer or counter offer, I can ask her to make contact with you early next week prior to the hearing in order to do that.
I wrote her several times. She haven't gotten back to me, so I'm just waiting on her. She haven't wrote me back or set up a conference call or anything. So I mean, if you can tell her to, she can find a way to reach back out to me. That'd be fine.
Okay.
Your Honor, so for the next, we're going to wait for the next court date for the resolution of to resolve all of the issues for the motions, correct?
Yes, now we have more particularity about the issues that you're bringing up, and that Thursday, February 4th at 3:30 is literally the only time I can get it on the calendar before the February 10th trial date.
Okay.
And then bond continues. We'll be back a week from today. Thank you.
All right. Your Honor, can I get a transcript copy of today's court? Can I get that sent over to me?
It does cost money to do that.
How much does it cost? How do I pay?
Let me get some information. It's $2 per page. The court reporter does not know how many pages it will be because she just took it. And then that have to be paid ahead of time as well.
Okay, so do I just send out I'll send a check out to the clerk of courts, right?
No, you'd have to make it out to the court reporter personally. It's Jennifer Fick.
Okay, I have her information, so make it out to the court reporter and send it to the clerk of courts, right?
No.
Who do I send? What's the address that I send it to?
P.O. Box 23600. And address it to Jennifer Fick.
To Jennifer.
In branch 8.
Okay. All right, thank you.
Are you expecting to have it before the next hearing?
I'm gonna try to get it sent out today, so hopefully, yeah. Okay, I'm gonna get it sent out to her as soon as possible.
Let me see what the feasibility of that is. That will be a challenge to do that, to do all of that, and you receive the actual transcript by next Thursday at 3:30. But if you haven't received it yet, then we'll just have to address it at that time.
Okay, that's fine.
Okay.
All right.
Okay. And then
Thank you.
That's all. Thank you. And then we have nothing until 4 o'clock.
Finished?
Yeah.
Yeah, now all we gotta do is get Judge Hawk to do it. And then I can go.
You want to move out of here next?
Attorney Brabazon, do we have you? I think.
Yes, I'm here.
Okay. Okay, now we can see you. I think we're still waiting for the prosecutor. We do have 2 cases scheduled for 4 o'clock. Christianity Mead and April Goodletson. I think Ms. Goodletson is still missing her lawyer. We don't have Attorney Herman yet. And then the DA's office hasn't signed on yet either. Okay, we have Attorney Herman now. There are 2 cases scheduled that's for 4 o'clock. And unfortunately, Attorney Herman, I think we're going to take Attorney Brabazon's case first because we have a doctor here to testify, possibly.
Okay.
It's a competency case. And then it looks like the prosecutor is signing on right now. Okay, looks like we have the prosecutor. This is Brown County case number 19 CF 1718, 20 CF 1203, 20 CF 1313, ECM 03. And Ms. Mead, I am going to mute your device just because there is a background echo in that room. So we'll have it muted unless we need you to speak. Thank you. The state is here by District Attorney David Lezay. Attorney Shane Brabazon is here. Ms. Mead is appearing by video from the Work Release Center. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. And I would also note that Dr. Thomas Speech is present as well. Attorney Brabazon, I think you were seeking clarification on what Dr. Speech was recommending. That's my recollection. Do you require his testimony here today?
I believe we will, Judge. I had sent an email to Caleb Saunders either late last week or earlier this week. I think it was earlier this week, actually suggesting that I've seen some improvement, some significant improvement with Ms. Mead in my dealings with her. I know in the evaluation that was done quite some time ago, Dr. Speech had suggested it was somewhat unclear if there was some type of, and again, this is my words, not his words, I'm not going to quote him, but that there was a question of whether this was really a problem stemming from her withdrawal symptoms from the significant use of drugs, or if this was more organic and had a more significant underlying mental health diagnosis. When I had emailed Mr. Saunders, I actually thought it might make some sense to have Dr. Speech do a follow-up evaluation. I wouldn't be requesting that if I had not seen such a marked improvement in her behavior and her understanding me and not having to be redirected like I've had to do in the past. And that's something I suggested to Mr. Saunders, but I don't know if Mr. Lassay had an opportunity to review the report and if he's got an opinion on that.
First of all, Mr. Saunders is in a shooting trial this week, so I apologize if he hasn't had a chance to get back to you. I doubt he's had a chance to look at this. He's been in trial the last 2 days. You know, with respect to that request that Ms. Mead be reevaluated at this point, I mean, it's been quite a while, I think, since she was previously evaluated. When would we be normally up for a status on her competency?
I think it'd be every 90 days.
And how far, what's the time frame? We gotta be getting close to that, right?
It looks like October 26th was the date of the evaluation and the date of the report, November 3rd.
So
yes, it would be, I think, really close to 90 days today from when the evaluation was done anyway.
Correct. I mean, I think frankly, we're at that review point, right? If it was October 26th for the evaluation, 90 days would be January 26th. So I think there's certainly some value in reviewing that. Typically, we receive information from the location where she's receiving the treatment.
We haven't had a finding of competence yet, Dave.
Oh, really? We didn't even get to that point? I apologize.
Correct.
Okay.
Yeah.
All right. But if it's been 90 days and you've seen a market improvement, if Dr. Speech is willing to redo the evaluation, then I don't have any objection with that.
So Attorney Brabazon, is that the request that you're making on behalf of your clients?
Well, that's the request. I would probably like to hear from Dr. Speech as well to see if that's something that he thinks may be valuable and if he's willing to do such. Dr.
Speech, if you want to comment.
I think that makes a lot of sense. Attorney Brabazon is correct that, my opinion at the time was that it was difficult to distinguish the acute effects of a substance from potential underlying more chronic mental illness. So if that's the request, I would just ask that the court request the reevaluation through the Wisconsin Forensic Unit.
Okay. So would they appoint you to do the reevaluation or not necessarily?
To be perfectly honest, Your Honor, I'm not sure. They have a variety of people, and I've yet to understand how they make decisions about assignment.
Okay, understood.
Judge, I think you potentially could specifically make that request, and I'm guessing they would honor it.
Okay.
And I've had this situation, Judge, where we had a reevaluation done by a different doctor, and it caused lots of problems. We ended up having to have a third evaluation done. So if I would have no objection if the court would suggest that it would prefer for Dr. Speech to do the evaluation.
Okay. Then I will grant the request. I think it does make a lot of sense. So we'll have a new competency evaluation done. We'll note that we'd prefer Dr. Speech to be able to do it again.
And I should let Dr. Speech know that Christy is in the work release center of the Brown County Jail, which is attached to the courthouse in Green Bay. It's you get to it on Adams Street in Green Bay.
Familiar where it is. Do you know, are they allowing in-person visits? Are they doing video? How are they doing that kind of thing?
I think they can do both, but I'm not sure. I know for sure they are doing in person. That's how I've met with Ms. Mead. I don't know if they've set up the Huber facility for the jail virtual visits yet.
Okay, thank you.
And then I think that the report would be due within 30 days. How about Friday, February 26th at 3:30?
That's fine from the defense.
And I think I'm not going to require Dr. Speech to be there. If somebody wants him to testify, then we would schedule it for the testimonial hearing, just like we're ordering a new competency evaluation. Understood?
Understood.
Anything additional from the state?
Sure, thank you.
Attorney Brabazon, anything else?
No, Your Honor.
The bond continues, and that's all for today. Thank you.
Your Honor, would I be able to have a breakout room with Christy?
I think so, yes.
Thank you.
They might cut you off at some point, though, if they need the device. Okay, Attorney Herman, then your case is next. April Goodletson. This is Brown County case number 20 CF 533, State of Wisconsin versus April Nicole Goodletson. The state is here by District Attorney David Lassay. Attorney John Herman is here. Ms. Goodletson is appearing by video. Ms. Goodletson, can you confirm that you can hear me and see me?
I can hear.
Okay.
And I can see you.
Thank you. And we can see and hear you. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. We're here today for an oral ruling on a motion filed by the defense. That's tangential from the preliminary hearing decision. Attorney Herman filed his brief. The state filed a brief then with their position. I think it was ADA Saunders that filed it. And then I did review the reply brief filed by Attorney Herman as well. I am prepared to make an oral ruling. I don't want to deny you an opportunity to present anything additional. Attorney Herman, did you have anything additional to present?
No, I think I'll just rest on what was submitted in writing.
And DA Lassay, anything else?
No, Your Honor, I'll do the same. I think there's substantial briefing for both parties.
Okay, thank you. The first thing I will point out is that I did not do a de novo review. I did not think that that's what the motion was. So after my decision here today, if either party wants to request a de novo review, you are still free to do that. It seemed like a legal analysis over the actual bind over decision by the court commissioner and not a de novo review factual analysis that was being requested. And then I reviewed the preliminary examination statute 970.03. It seems that sub 7 through sub 10 are the substantial part of the analysis. Sub 7 says if the court finds probable cause to believe that a felony has been committed by the defendant, it shall bind the defendant over for trial. And then 8 says if the court finds that that it is probable that only a misdemeanor has been committed by the defendant, it shall amend the complaint to conform to the evidence. The action shall then proceed as though it had originated as a misdemeanor action. That one doesn't seem to apply to what the commissioner's ruling was. Sub 9, if the court does not find probable cause to believe that a crime has been committed by the defendant, it shall order the defendant discharged forthwith. And that does not seem what the commissioner ruled either. And then sub 10, which I think is the important one that Attorney Herman pointed out, in multiple count complaints, the courts shall order dismissed any count for which it finds there is no probable cause. The facts arising out of any count ordered dismissed shall not be the basis for a count in any information filed into Chapter 971. And I did review the Williams case, which I thought was the most on point to this analysis. And a quote from the Williams case basically quotes sub 10, and it says sub 10 is a new provision requiring a finding of probable cause as to each count in a multiple count complaint. If such a finding is not made as to any count, it shall be dismissed. And when I consider what multiple count means in the analysis, I think it's very, I think when you consider the entire statute and Williams as a whole, that multiple count means multiple felony count. If you look at sub 10, the word count appears in there 5 times. And the entire preliminary hearing statute is only about felonies. It's not about misdemeanors. And when it says in multiple count complaints, the court shall order dismissed any count for which it finds there is no probable cause. Well, the state does not have to show probable cause of misdemeanor counts at a preliminary hearing. So if we were to take count in that sentence to mean misdemeanor or felony count, that's not an accurate statement then, because the state does not have to show probable cause for misdemeanor counts. For example, if we take the exact same fact set that we have in this case and add on at the end that the accused person had marijuana in their pocket, for instance, and there was an additional misdemeanor possession of THC count as count 3 in this case, the state wouldn't have to present any evidence of possession of THC at the preliminary hearing. And then that sentence there doesn't make any sense. The court shall order dismissed any count for which it finds there is no probable cause. So I think when you review subsection 10 in its entirety, that it uses the word count 5 times, that section only makes sense if it's referring only to felony counts. And in this case, there was only 1 felony count. And that also is consistent with what happens at a preliminary hearing, because if there's only 1 felony in this case, and the court commissioner is allowed to say there's probable cause that a felony was committed, but this 1 count of, I don't think there's probable cause for specifically, so I'm going to dismiss it. Now we're left with a case that doesn't even have a felony count on it. It's only a misdemeanor, even though the commissioner determined that there is a probable cause that a felony was committed. And if it's not a multi-felony count complaint, then it goes into sub 7 if the court finds probable cause to believe that a felony has been committed by the defendant, it shall bind the defendant over for trial. And in this instance, if we just dismiss the count at the preliminary hearing because the commissioner ruled there was no probable cause for the count that was charged, but had this general, there was a felony committed, the state wouldn't be able to instantaneously change the charge. And I think that would be usurping the quasi-judicial role of the prosecutor, which is discussed in the Williams case, having discretion to bring charges. The preliminary hearing is a statutory right, not a constitutional right. It is a very important proceeding in a criminal case, but the purpose of the preliminary hearing is not to take away the quasi-judicial discretion of the prosecutor, but, and I am quoting the Williams case now, to protect the accused from hasty, improvident, or malicious prosecution, and to discover whether there is a substantial basis for bringing the prosecution and further denying the accused his right to liberty. And I think the court commissioner satisfied that purpose by making the bind-over decision, binding the defendant over for trial after finding that there was probable cause that a felony was committed. And now I'm quoting Williams again. The purpose of the preliminary hearing was satisfied upon the commissioner's finding of probable cause to believe that Williams had committed a felony in connection with the attack on Bowie. And then there's a case called State v. Burke, B-U-R-K-C, that is cited in the Williams decision. And then when I read that case, Burke even allowed the prosecution to basically circumvent the multiple count statute section by dismissing all but one count right before the preliminary hearing, and then allowing the counts to be added back into the case after the preliminary hearing, because they were transactionally related to the one count that was bound over for trial. And then, although I did not do a de novo review on this case, I would need to review the video myself if I was to do that. My understanding is that was shown at the preliminary hearing. I would note that Attorney Herman includes a sentence about the facts, and that quote was, "The video shows Ms. Goodlickson making one swiping motion with a knife in the direction of the alleged victim. No physical contact is involved, and the alleged victim is already around the corner of a door and moving away from Ms. Goodlickson when she makes the swiping motion." And just based on that fact summary, I don't think it's fair to say that the charge that there is right now in count one lacks any merit at all. I think no merit at all would be if the evidence showed that it was the wrong person, or if the video maybe conclusively showed that she was holding a cell phone instead of holding a knife. And those are just two examples, not all of the examples I can cite for it being of no merit. So when I review the statute as a whole, with the cases that were cited by the parties in their briefs, I am going to deny the motion to modify count one. And then for scheduling, did we have the arraignment yet?
No, we haven't completed the arraignment, and we can do that now if the court would like.
And did you talk to your client about the video conference appearance for the arraignment?
I know we have, but if Ms. Goodlinson wants to review that, we can.
Ms. Goodlinson, we're moving to the arraignment now. Your client or your lawyer will enter a plea on your behalf at an arraignment. You do have a right to be present in person in the courtroom for an arraignment. Are you willing to waive that right so we can continue with this video conference appearance?
Yes, I am.
Okay. If it becomes necessary to talk with your lawyer privately at some point, we can accommodate that with this video conference procedure. Attorney Herman, have you received a copy of the information then?
Yes, we have. The information was originally filed on August 6th, and Ms. Goodlinson is aware of the charges contained within it and maximum potential penalties would waive any reading of the information. And at this point, she did the entering pleas of not guilty.
The not guilty plea will be entered into the record. And then would you like to schedule a status conference date or a trial date?
At this point, I know there's going to be at least one other pre-trial issue we're going to need to take up. So if we could schedule for status.
How about Tuesday, March 9th at 1:30?
That would work for me.
Anything additional from the state?
Yeah, thank you.
Attorney Herman, anything else to take up for today's purpose?
No, I don't believe so. Thank you.
Okay, then bond continues. That's all for today. Thank you.
Thank you.
And I think that's the last hearing of the day.